That's the verdict of the Ghana Bar Association.
Okay, so first of all, I need to say that I disagree forcefully with my association president. But you see, the Ghana Bar Association, if you look at its intervention historically, maybe it takes a lukewarm attitude when it's within certain regime, and certainly finds its, possible voice in certain other regime. And I'll start with this. If you recall, under President Rawlings, we had a justice of the Supreme Court called Abba. Now, what happened was that the Ghana Bar Association had very strong views of Justice Abba. And in order to trigger the provisions of Article 146, which requires that the removal of justices of the Superior Court should be on grounds of stated misbehavior, on grounds of infirmity, unable to perform their function, among others, the Ghana Bar Association decided to use the instrument of a writ action. Now, when the matter came up for hearing, and it was actually adjudicated, incidentally, His Lordship Justice Kwega, His Lordship Justice Ajabin and Co. Had this to say, and let me go back and read. Let me even go back and read quite the reasoning of the Supreme Court when the Ghana Bar Association decided to use an unconstitutional means to get a Supreme Court judge removed. And I don't know how President Mrs. Sefua Gate would describe that, whether a bad precedent or not. Now, when the issue came up, the Supreme Court, speaking through His Lordship, Justice Ejabin, had this to say. Can I read it?
Yes. Yes, you can.
That's the Ghana Bar Association versus Attorney General and another, 1995-1996, One Ghana Law Report at page 598, quote, "It is clear from the above that under our Constitution 1992, a Chief Justice or a Justice of the Superior Court or Chair of the Regional Tribunal can only be removed from the office by the President acting on the recommendation of the committee appointed by the President or the Chief Justice, as the case may be, to inquire into a petition sent to the President alleging some misbehavior or incompetence against the one concerned." It proceeds. "It is important to note that Article 146(8) of the Constitution 1992 provides that the proceedings of the committee appointed to deal with such petition shall be held in camera. It is mandatory. Said that proceedings held in camera, not in public or open court, as unfortunately being done in this case." So you know what the Ghana Bar Association did? Instead of triggering Article 146, they rather issued a writ to achieve the same aim. Do you get it? Now, the reason for this important provision is obvious. It's to preserve, protect, safeguard the authority, dignity, and independence of the judiciary. It will be a sad day for this country if the court were to grant the request of the Plaintiff Association and start removing our judges in open court, contrary to the provisions made in the Constitution for that purpose. It is in the light of these observations that I consider this action of the Plaintiff Association, I mean the GBA, who should be expected to know better. Listen carefully. that an association, the creme de la creme, Lawyers Association, should know better. Most unfortunate, as is likely to undermine the judiciary in particular and the rule of law in general. The reason why I decided to go back to 1994 is to underscore what the judiciary, the Ghana Bar Association and its intervention over the period has been. I am not surprised at all. Look, when President Mahama decided to appoint 2 justices of the Supreme Court, His Lordship Justice Kwaman and Justice Yao Apao, it came the Ghana Bar Association to President Mahama to court. The association was almost quiet until the later end of President Akufo-Addo when they started speaking. Why so? With respect, what is it relating to these impeachment proceedings against the leadership, the Chief Justice? That is untoward. That is a bad precedent. That has not been put out. Has any provision of the 1992 Constitution been undermined? No. I am looking forward. And look, thankfully, my good brother, the Supreme Court, even in this matter, has had the opportunity to intervene, either by describing an act unconstitutional or not, either to injunct a process or not. The Supreme Court has effectively agreed. Now, how come that an association of lawyers, with respect, appears to take a view? And when you say a bad precedent, I've been struggling, I've been struggling to understand what exactly is it that is bad. Because first of all, I am not the maker of the 1992 Constitution. I do not think the president of the Ghana Bar Association, President Mrs. Efuagati, is one of the framers of the Constitution. I do not know. But in the wisdom of the framers of the 1992 Constitution, they actually envisaged, saw into time, that there will be a day that a Chief Justice may be alleged to have misconducted herself and which will require a hearing. Are we, for any reason, saying that those provisions in the Constitution are bad? Is that the suggestion? Because if those provisions are in the Constitution and are being used, where is the bad precedent? With respect, once again, President Efuagati appreciate greatly that the position of the justices of the Superior Court and their removal processes by way of security of tenure applies with all necessary modification to independent constitutional bodies. So when President Mahama, having received a petition from Richard Nyama, Frank Anodompre, led by way of counsel, Mr. Samson Ladia Yenedi, for the removal of Mrs. Vivian Lamptey, Loretta Lamptey, the Strat Board, an appointee of the NDC. Was it a bad precedent? Because in the same Article 146 that was used. And I remember when President Mahama received the petition, right, from Richard Nyama, what President Mahama did was to give it to her ladyship Georgina Wu, then Chief Justice, to make the prima facie determination. After she made the prima facie determination, her ladyship Georgina Wu then set up the Eniegua committee. It was my Lord Justice Eniegua, Justice Anthony Brennan, and her ladyship Mariama Owusu, to make an inquiry into the specific allegations against Loretta Vivian Lamptey. Eventually, the committee recommended her removal. Prior to the removal, in a release by the then Chief of Staff, Prosper Barney, in 2015, President Mahama suspended Loretta Lamptey. suspended her. How different is that from what has happened today, 10 years after? Was it a bad precedent? As recent as I think 10 years ago, we saw President Nana Dankwa Akufo-Addo apply the same provisions of Article 146 in the removal of Madame or Mrs. Charlotte Osei, in the removal of Mrs. Amankwa and the late Amadou Sule. Was it a bad precedent? I mean, where from this sudden claim that a full compliance with the constitutional provision constitutes a bad precedent? When President Nana Dankwa Akufo-Addo removed the head of an independent constitutional body like the Electoral Commission, the bar never issued a statement. Please, unless of course the bar intervened and I'm not aware. If you know, please give me the benefit of knowing how the bar intervened when Madame Charlotte Osei was removed. I want to know. In fact, I recall vividly, and I'll say this. After the removal, Mr. Kukubaku, the respected journalist in this country, went to the Supreme Court to say that the removal of Charlotte Osei on mere grounds of procurement breaches without no further evidence, either she has stolen public funds or not, the Supreme Court refused to entertain that process. In fact, the lawyer for Kukubaku was my senior, Samson Ladi Ayenede. The Supreme Court resisted a writ action to challenge the removal of Madame Charlotte Osei. Was it a bad precedent? You see, the accounts have a saying. Yes, so way of one side. So way of one side. No, I share one side. You know of war. You know of war.
That's
the monkey.
Monkey. It's a monkey. Exactly. But that call, this call for the reconsideration of the suspension, if you listen to your president, your bar president, says that in the spirit of reconciliation, they're hoping, and he says we, essentially representing the position that you, the members of the Bar Association, have taken, that the various calls for the reconsideration of the Chief Justice suspension will not be ignored, especially given the poor precedents that is set.
You see, when President Mahama...
That's what he said.
No, when President Mahama suspended Loretta Lamte, he gave a policy reason. And in fact, it was at the invitation of the petitioner. You know what the claim was? That as the head of SRAJ, the reason for the petition was or had to do with payments and others, because she was supposed to go to a short residence, she didn't, she was in a hotel, all kinds of things. And they said, look, if she is still there, listen carefully, the possibility of evidence suppression, among other things, will be profound. Huge possibility. So President Mahama suspended Loretta Lamte. Was it a bad precedent? But you see, let me tell you something today. In the removal process of a leadership, Gertrude Torkonor, do you know that judicial service staffs are testifying before the proceedings?
Judicial service staff are testifying.
Yes.
Before the committee.
The committee, yes.
I see.
Imagine testifying against your boss. And look, for want of a better example, the general manager of Media General.
No, you can use another example. let's
let
but I get the point.
Let me use another example. So in this specific case, where judicial service staffs are witnesses, and imagine the CJ still being in office. Can you even have the courage, my brother, in even going there? That would even lead to suppression of evidence.
I see.
So in good conscience, the suspension, and like President Mahama acted previously, guess what? In the wisdom of the framers of the Constitution, unless of course, we say we are wiser than. Do you know something?
Mm-hmm.
If you look, the 1968 Constitution, 79 Constitution, didn't even have these provisions. For instance, the in-camera hearing, they were never in those provisions, right?
Mm-hmm.
It was for good reason why in the 1992 Constitution, having reflected on our past history, decided to have these two provisions, the in-camera hearing, the suspension provisions. We cannot for a minute, and I do not think that the Ghana Bar Association is suggesting even remotely that they are wiser than the people who put the Constitution together. I do not think so. And look, let me say this. There have been issues. The proceedings are happening at Edu Lodge. Why? Why is it not happening at the judicial court complex? Look, my brother Alfred, can you imagine a situation where the head of the judiciary will now be coming back now, like for want of a better word, like somebody accused?
Mm-hmm.
I mean, so these are all the reasons why the committee members came out and said, look, let's get a place so comfortable, a place so detached from the judiciary, where she can feel comfortable, appear quietly, no media razzmatazz. Have you seen that there have not been any media, things about the proceedings quietly until a press conference the last time? I want to say this, and I say this forcefully. President John Dramani Mahama, took the oath of office before her ladyship, Justice Gertrude Torkonor, and swore an oath, which oath is swore that you do justice to all manner of persons, but more importantly, respect the laws of this country. What else can President Mahama do under the circumstance? Imagine, just for a minute, that President Mahama has taken a procedure that is not sanctioned by Constitution. Our brothers and sisters in the MPP would have used this as ground for his removal, as having breached the Constitution, particularly his oath of office. Now, a compliance with the Constitution should rather get the commendation from an association made up of lawyers. Where from this notion that this thing will create a bad precedent. What does it mean for a bad precedent? If tomorrow, look, tomorrow, an MPP administration comes, I don't know the outcome of the committee's work, and say, under President Mahama, a CJ was removed. Today, the Chief Justice of the Republic is Martin Quinn. And for that matter, I am going to remove, because even when there are no petitions, it's for that president. And let's remember this. No president, and I repeat, no president is happy superintending upon an impeachment proceeding against a chief justice. no president. And President Mahama is not an exception. But it's an uncomfortable duty that he must perform as sanctioned by the Constitution. Not doing would amount to a desecration, a violation of the 1992 Constitution. I am expecting that an association made up of lawyers, with respect, would ground their proposition in law and say, Mr. President, to our mind, what you are doing violates the Constitution. When President Mahama appointed Justice Poorman, when President Mahama appointed Justice Yawapao, the Ghana Bar Association, then led by President Nene Amegachi, Justice Amegachi, what happened? They went to Supreme Court to challenge that decision by President Mahama. So if the bar today feels strongly that a rule of law or a procedure, the Constitution, has not been complied with, why not use the court rather than draw President Mahama into a conversation not specifically grounded in law? That kind of invitation, with the greatest respect, ought to be declined. Okay. And that is why you see that the call, more or less, for a reversal of the suspension to be an invitation to the president to engage in an unconstitutional conduct.
I see. But
until then, I think that we should permit the rule of law to take its course. The leadership, the Chief Justice, is ably being represented by no other lawyer, by Senior Alikwe Otu, a very respected lawyer who knows his ways around the law, among others. And so I strongly believe once the evidence against the Chief Justice will be subjected to strict proof, rigorous cross-examination, I think that if it's without merit, it will become clear to everybody, Alfred.
I see. But let me bring in Dr. Jato here on this matter, because flowing from what Edvidence has indicated, it is a constitutional, and this is something we've said consistently here, a constitutional provision that is at play, essentially, and the president following the dictates of the Constitution. The Ghana Bar Association hasn't departed from its position that, in their view, this is not the way to go. Essentially asking that she be reinstated and then the process will play out. This morning, we're just getting some new information from Lawyer Edvidence that there are judicial service staff who are essentially witnesses or testifying against the Chief Justice at this hearing of the committee of the petitions against her. How prudent would it be to have her reinstated when this process is going on with such detail as we have heard this morning?
Thank you very much. It's always going to be difficult to follow a lawyer when we are talking about law. So he's the expert, so it's like I'm the only non-lawyer, the two of us. Yes. So it's difficult to follow a lawyer when it comes to legal issues, because I'm going to say that he's going to quote the constitution and say, hey, this is not the case. But I'm going to try. So I'm going to try to see what I can do to follow what you've said. The first thing is, how come you know so much about the process? It's just curious. You are not a lawyer to any of the people there. You are not in the room there. How did you come by this information? It's prime information. It's sensitive information. It's detailed information. Who gave it to you? I think we should find out that, because I can understand if you were in there, if you are one of the lawyers, then of course, is that covered by lawyer-client privilege? Then I won't probe. But if not, I would really want to know, and I think the public wants to know, how you know that people are testifying when you are not part of the process in any way. You are not a lawyer for any of them. So that is like something curious. It just hit me, and it is. Secondly, my position on this Chief Justice thing is known. It's a beating I've said it here again and again and on so many platforms. I personally think she's gone. I personally think that she's not going to win this case. I personally think that is done, that she's not going back to that office as a Chief Justice. I've said that. Two, I've also said that I'm proud of her fight against the case that she's taking on. In fact, Edvidence just said something that Kwaku Bakwenko challenged the case of Supreme Court. It was true now. Probably if it was entertained and then the judge, the Supreme Court comes out with its rulings, maybe they would have helped a lot in the current issue. So I'm happy that she's fighting it. I'm happy that the cases are going to Supreme Court. The Supreme Court is making rulings. And the last time you said I was right when I said that it will help the general jurisprudence of these cases. So again, I'm happy that she's fighting it. I'm happy that she's not sitting down and just taking it, that she's going all out. In fact, I'm even happy that she has also taken her case to the general public. Basically inviting us into this very sensitive case. You said, look, this is what is happening to me, and I'm the Chief Justice, or I was a Senior Justice. If this is happening to me, you can imagine what will happen to you. So again, I think her fight, I've said it, is virtuous. I think her fight is right, and I think that people will learn from her. Look, when we hear the history of Yaa Asantewaa, I don't think Yaa Asantewaa thought that she was going to defeat the Europeans when they came. No. It was the fact that she realized that no, even if they lose, somebody has to stand and fight for something. It's that they did believe that not standing up to fight a system that she believed was bloody, injustice, and would kill them is worse than fighting and dying with pride. So I think this woman is fighting so that even she dies with honor, she dies with dignity, she dies with her pride. And I think that's what. So I salute her for that. I think it's a good fight. It's a right fight. She should go ahead, and whatever happens, she can be proud of the fight she put up. Sometimes in times of moral crisis, the deepest places of hell, we are told, are left for those who claim to what? Neutral. Yeah. Because it's important that you rise up, you raise your hand and you take a stand. And then you fight for it. You may lose, but history will remember that when the time came, you did not claim some anonymity, you did not claim some neutrality, but then you stood up and you fought. And I think that is what the Ghana Bar Association is doing. They are saying that, look, we might be wrong in law, as I'm saying, but history will record that. When this was happening, when the first time the Chief Justice of the Republic of Ghana was being removed under this constitution, when this grave issue was happening, we stood up, we took a position, and we fought for it. And that, for me, there is pride and there's honor in that. Look, if institutions of government or if public and private institutions are always stand up, there was a time we were talking when we started, people was rising up. Yes, yes. And that is what they are doing. Yeah. Is that rising? Is that to say that, look, hey, we are going to take a position, and we are going to defend this position to the very end. We are consistent, and now I think that is what they are doing. So for me, I'm glad that they are taking that position. Again, I don't know the law enough to know whether it's right or not, but the fact that they rose up, they've raised their hand, and they raised their hand, they're doing it. It's virtuous. It's a good fight, and I think that they're going to do that.
That's where the point about you not knowing whether it's right or wrong in law is where Lawyer Tamaklo was making the argument that you see you can take a position like this, you know, as a non-lawyer, essentially, and you say that in your view she's a goner. You maintain that position consistently, but then again, when it is coming from the Bar Association. The position cannot be analyzed in oblivion or outside of what the association stands for. It's a group of lawyers.
Thank you. So that's what I'm saying, that I will let the two lawyers, Martin and Edvidence, do that. And I think they have it covered. They will cover the legal. But I'm looking at it in terms of advocacy. I'm looking at it even standing for an institution, the bar. Those things can be political, it can be policy, and it can be advocacy. And I think that's what they are doing. They are simply trying to say that when this history is being written, let history record that the Ghana Bar Association for this. They are playing to history. They are making their case know that when one day this history will be written, and I've said it, anybody who will write the history of His Excellency John Dramani Mahama must know this. And it's not going to be an anecdote in his history. No, it's going to be a chapter, if not a book on its own. Ghana Bar Association wants to be known. In fact, they are also hoping that there will be a full chapter, if not a full book, dedicated to what they said and that they have been consistent in this fight. That is what I'm saying, and that's what it's good that we should take it away. And then I asked the question. There's a union representing that. She's supposed to be the head of that union, right? Where is the union?
I mean, okay.
The union of where is that union? I always believe that unions are biased. Natural unions are biased. In fact, unions do not exist for the institutions. That is, unions exist for the people in the institutions. The chief, did she pay her union dues? Or her union, did they pay dues?
If there's silence, what does the silence tell you?
I don't know. I'm saying, did they pay dues?
Yes,
so she paid her dues. So she's a union member. She pays her dues. She's a member in good standing. And now that she needs the union most, they are quiet. Like, for me,
what does their silence tell you?
I don't know. There could be two things. One, are they silent because they think she's guilty?
What's the name? Alfred.
Yes. Let's check.
You see, my brother.
That's a quick intervention. Yes.
Yes, a quick one. My brother Jatu is a political scientist. At least you should do a bit of our political history. If you recall, with respect, when Osagyefo Dr. Kwame Nkrumah was removed, okay, one of the judges who sat on the commissions to investigate Mr. Kofi Bakun and all of those, Igala and Co. was Justice Apalu. The history will show this. When the CPP, after CPP was proscribed and it came under demand, there was an attempt to remove Apalu using parliamentary proceedings. So that if Apalu had gone to Parliament and gone through the parliamentary proceedings as the Chief Justice of the new Supreme Court, right, what would then have happened was that they would take a vote on him and would have been removed. When the young lecturer there at KNUST, Dr. Amakutufo, took the matter to the Supreme Court, and then Court of Appeal, the court intervened and stopped the process, scattered it. Again, when the GBA attempted to remove Abba through the writ action, the court again intervened and stopped it. When my respected senior Brighter Kwete decided to remove Chief Justice Akwa, the court again intervened in Frankajechu and scattered it. Why this? Possibly we need to find out what exactly is happening.
Okay.
As a political scientist, maybe you should avert your mind to that.
Thank you.
Okay. Well,
again,
I think it's
those are more legal cases. I agree.
Well.
I mean, your knowledge about those things, I will not question them. But I'm still making the point. I'm making self-stands that the union, we've not heard from them. Maybe they could come out and say that this case is so bad that we will not touch it, or they could come out to say that we don't agree that we agree that there's merit, so we'll not touch it. But I'm saying that shouldn't history record their position? Shouldn't the history, when we are documented, shouldn't they, like you just rightly said, Eduji, that one day we will reference this case, talk again. Shouldn't we at least have the buy-in of that union, saying that this was where we stood, this is what we decided, this was what we thought when the time started? Because I think that is important. That gives us a kind of a more complete 360 perspective of this. That this is what the woman is saying. This is the law we've been told. This is what the Constitution has said. And this is what the bar has said. She's a member of the bar. At least the member of the bar has said something. As an individual, she's taking a position. And she's doing that both within the committee and in the press. 1. 2, she's a member of the bar. The bar has stated its position. 3. 4, she's also a member of the union. What is the union's position? I'm not saying the union should support it. That's not what I'm saying. I'm not saying the union should not support it. That's not what I'm saying again. But I'm saying that for the sake of history and for the sake of tomorrow, the position of the bar, if it's known, will help. So because tomorrow, one day, I think that the bar will come out to support somebody if the person is being fought. Or the bar will come out not to support somebody. And when that happens, we'll rephrase this. Like Eduji said, he made an argument that is very important. It seems that under some regimes, the GBA goes quiet. And under some regimes, the GBA becomes loud. Good. Then we can make that argument to that GBA. Why are you quiet when, they say, the NDC is in power? And why are you all of a sudden loud when the NPP is in power? Those are very legitimate concerns. We can ask the question, why do you do that? But it's in the same way that we are saying, because I think that, I don't know, maybe is it possible that in the past, the union has made pronouncement? Have they ever made pronouncement on none of these issues?
Okay.
If they have, why haven't they?
All right.
In this case.
Not that.
Or is it that based on their bylaws and everything, they are supposed to be quiet? If it is their bylaws or their rules of establishment that says that just be quiet when this is happening, then I respect that. But if there's no provision like that, at least we should know their position.
Well, but